Thank you. Ladies and gentlemen, I have the pleasure to present my presentation. My name is Ivars Kronis. I represent Riga Stradiņš University, but have a special relationship with the University Turība, as well as with Mykolas Romeris University in Lithuania. And presently, I'm also a sworn advocate of law. In my presentation, I will go back to the beginnings. The main problem which exists today is that there are more disputes than the court system is able to settle. So mediation is not something entirely new. As I already mentioned, such methods have been used even before the court system was established. And this method was used because there was a need to resolve a dispute economizing time and resources. And the dispute resolution of this kind was developed before the legal means, the court system. Mediation is close to the negotiation process, but it is a more developed form of it. And differently from the litigation process, as well as differently from the arbitration process, the mediator does not make a binding decision, but encourages the parties to find the right settlement, the right decision. And the third person doesn't do it for them. So the parties themselves settle their dispute as they wish, or if they wish. The mediation process also has to be interpreted from the point of view of law. And one example which I have used in my lectures is the so-called example of two sisters. And this is an example which shows how mediation works. And the example is as follows. A mother has two daughters, and she has only one orange, and both daughters want the orange. And the mother wants both her daughters to have the orange. The question is how to divide this orange for the two daughters. Now, the decision would be according to the law, and that would be to divide the orange in two halves and to give one half to each daughter. But mediation allows to view the situation from the point of view of interests, and not just from the point of view of law. And perhaps in this orange, one daughter wants only to squeeze out the juice, and that's why she wants the orange, while the other daughter wants to bake an orange pie, and she only wants the pulp. And when we clarify the positions and what each party really wants, then if we know the interests, one of the daughters wants the pulp, the other wants the juice, and then the dispute can be resolved according to the parties' interests. So the main difference is that the law will solve the dispute in a fair way for each party, and as a result, one of the daughters will get only half of the glass of juice, and it will not be enough for her, and the other will not get enough pulp to make the pie. But still, we have to discuss the mediation because in practice, it is not as popular as we may want it to be. And which are the main problem questions which we need to discuss? The previous speakers already touched on these aspects. And we as lawyers and advocates of law particularly have the duty to keep to certain standards, and that is the legal regulation. And sometimes it is difficult for us. We are aware of what the law wants, but we want to argue, we want to achieve justice. And the law sometimes can hinder us to find the most fair solution. And sometimes when the advocates meet, we discuss these matters and we think of how to find a compromise. And if one of the parties starts behaving aggressively, and the law envisages the following actions and so on, and in such situations, it is difficult to find a compromise, as the settlement is seen as just one of the parties signing the condition under the conditions of the other party. But that is not the ideal settlement. Ideally, both parties should be satisfied with the settlement and with the agreement. And there are also financial risks, which have been discussed by many and also by the books. If we as lawyers settle the dispute quickly, we will earn less. But there is the other side. If we help them to settle their disputes fast, the clients will be satisfied, and that will contribute to our reputation. But there is one more binding problem. We as lawyers, as advocates, always think of what the client will think of us, whether we are militant enough, whether we are ready to defend the client. And as a lawyer, I have had cases when at first we agree with the clients that I'm going to represent their interests. And then after some time, the client has changed his mind, and he says, no, I have changed my mind because I'm looking for a different lawyer. You are not aggressive enough, and you are not assertive enough. So this is also a problem in the work with the client. The client should be persuaded by the lawyer that perhaps this case should be reconsidered, and a more respectful atmosphere should be maintained. We need the law and norms, and for the mediation to work, we must also consider the breach of ethics that the lawyer would face. The lawyer would breach the code of ethics if he doesn't inform the client about the possibility of mediation, because the code of ethics envisages that the lawyer should inform the client about the possibility of mediation. If the client refuses, it is his decision, but at least he should be offered the possibility of mediation. But here is another problem. At least in Latvia, this institution of representation of the client is rather liberal, and advocates are not the only lawyers who can represent the client. And if, on the one hand, for the advocates, we will apply strict codes, strict rules of ethics, so that they would always have to offer mediation to the client, then the other legal professionals will be free from this obligation, and they may also represent their clients in the court. So one of the problems is such that the advocacy procedure is not accessible sufficiently, and advocates as professionals for whom the norms of ethics are binding will use the opportunity to offer mediation more widely.
And speaking about cooperation between mediators and attorneys, lawyers, I would like to mention another aspect that was already mentioned by my colleague, that lawyers have more trust from the client. And when we have all these emotional conflicts, then lawyers have the possibility to say, let us not speak so much about the emotional side of this. And this is then maybe a good thing. Also, when I speak about divorce, on the one hand, on commercial arguments, I would say that commercial people, I think, are more pragmatic, and they are not, and all these things are not so much related to their personalities. They look at the business interest. But there are also this emotional side sometimes in the business conflicts. It's not always just about commercial resolutions. There's also a lot of emotional reactions there, even there. So this was what I wanted to mention from my side, and I hope that we shall somehow succeed with mediation.